Okay, ladies and gentlemen, it's nursing instructor Matt with your complete idiot's guide to the Saskatchewan Mental Health Act. You are, in fact, not an idiot. You're a very lovely and capable person, but when the Saskatchewan Mental Health Act is new to you as a student, it can be a little bit confusing. So we're going to go over some of the highlights and some of the things that you need to know as a student that may impact your clinical experience and just your general overall knowledge. Just before we start, these are my own views. They don't reflect the views of any institution, and this does not constitute legal advice. Also, if you're not from Saskatchewan, this will not apply to you. Okay, so in Saskatchewan, we've had mental health legislation for a long time. It basically guides who can receive treatment and under what conditions they receive treatment, and it sets rules and regulations for clinicians under the law. We've had mental health legislation in Saskatchewan since about 1906. That was called the Insanity Act. My very favorite version of mental health legislation in Saskatchewan was in 1916 when they came out with the Act for the Management of Dangerous Lunatics. So, luckily, we've come a long way in not having stigma-affirming language like that. Okay, so when we're talking about in-hospital treatment, basically we have two main streams. We have voluntary and involuntary. Voluntary is just what it sounds like. The person involved in that admission believes that they need help, they believe with the treatment regimen, and they have insight to make their own decisions. This is more often than not the preferred route. However, sometimes due to mental illness, people don't have that insight. They can't make informed decisions about their care because they are unwell, and they do need hospitalization in order to improve. The criteria for involuntary admissions is basically because of mental illness, you're at a risk of harm to yourself or others, and without treatment, your mental health is likely to deteriorate. So that's kind of what we'd be looking at. So that's your voluntary and involuntary admission. For involuntary admission, there are forms associated with that. We're going to talk about that in a slide coming up. Okay, everyone freaks out about forms under the Mental Health Act. There are a bunch of forms. There's tons and tons of forms. We have a saying, if you want to do anything under the Mental Health Act, well, there's a form for that. These are the main ones that you're going to need to know as a student, okay? So the first one that we're going to see is a Form A. So this is a certificate for psychiatric examination. And this is more often than not filled out by a doctor, usually in our case, an ER physician, when somebody comes in and that physician feels like they need to be seen by a psychiatrist. So this form can hold you in the in the emergency department, for example, until on-call psychiatry or psychiatric residence sees you. So a good way to remember this, and this is really stupid, I'm sorry, but a good line for you would be, I think it's a good idea for you to be seen by a psychiatrist. Okay, so that's Form A. Form G, we see this all the time up on the inpatient unit, and these are the forms that get filled out when somebody is admitted involuntarily. So they meet that criteria for involuntary admission, in that because of mental illness, they're a risk to themselves or others, or without treatment, their mental status is likely to deteriorate without treatment in the hospital. So the first Form G is filled out generally by the psychiatrist or resident that sees them in the emergency department. And that first Form G holds a person in the hospital on the unit for up to 72 hours. Within that 72-hour time period, a second psychiatrist has to come see that individual, interview them, assess them, and they either agree that the person needs to go be admitted involuntarily, or they disagree, in which case the person becomes voluntary and they're able to leave. If that second psychiatrist agrees, then a second Form G is filled out, and that second Form G can hold the person on the unit for up to 21 days. That doesn't necessarily mean they're going to be there for 21 days. If it's deemed that the person needs to be on the unit longer than 21 days, a new set of Form Gs can be filled out, and this process repeats itself. So we talked a little bit about the criteria. There is an appeal involved in this process that the person being admitted is entitled to, and we'll talk a little bit about that. But the good way for you to remember the Form Gs 1 and 2 is get your butt into the hospital. Okay, so you have to be there involuntarily. Form H is a revocation of a certificate. So that person no longer meets the criteria for involuntary admission, and then generally they're ready to be discharged home. Sometimes they'll stay voluntarily, but it just means they don't meet their criteria, so the certificate is revoked. And then we have certificate for electroconvulsive therapy on an involuntary basis. So a person that's been certified under the Mental Health Act, so they have 2 Form Gs. Their psychiatrist says ECT is the best course of therapy given their condition. That person can't consent because of their mental illness. So their psychiatrist will outline why ECT is the best course of action for them. That's the first Form I. Then a second Form I is filled out by another psychiatrist who's not directly involved in their care, and they either agree or disagree with that course of treatment. This one also requires an appeal. So Form I's is for the involuntary administration of ECT therapy. Okay, and then we have community treatment orders. This is something that Saskatchewan has written into its legislation that allows people to live in the community and be under certain conditions for their treatment. Okay, so oftentimes that might be I have to show up for my appointments with my psychiatrist or my community mental health worker, or I have to show up at a certain place at a certain time for my depot injection. So these are sometimes conditions that are outlined in the CTO. If the person is unable to comply with those conditions, they can be brought by city police to the hospital to receive the treatment that they need. Doesn't necessarily mean that they'll be admitted. It just means that it gives the mental health care team some leverage to make sure the person gets the treatment that they need. So there's 2 parts of it. The H3 is the community treatment order itself that's filled out by the attending psychiatrist, outlining the conditions that the person needs to meet. And then H4 is a certificate in support. So basically saying another psychiatrist again comes in and assesses that individual, says they agree with this course of treatment, and this H4 is the support, the certificate in support of the CTO. These also require appeals, which we'll talk about in the next couple of slides. And they're reviewed every 6 months. So a good way to remember this is H3 is the rules, and H4 are the reasons for those rules being put in place. So that's H3 and H4. So another person that you're going to hear about is the official representative. They are a lawyer that's appointed by the Ministry of Health to help people navigate the Mental Health Act who've been admitted involuntarily. So they act as an advocate on their behalf. They advise them as to their rights and responsibilities under the Act. They assist in the appeals process, which we will talk about, and they also monitor to make sure that the Mental Health Act is being complied with from the caregiver side of things. So appeals are a way to challenge decision-making under the Mental Health Act, okay? It wasn't very long ago that if Matt was your patient and you said, Matt's a little bit off, we're really kind of worried about him from a mental standpoint, you might be able to take me to a large state-run hospital like we had in Weyburn, for example, and say, we can't handle him over at Sask Polytech anymore at the nursing school. He's too out of control. He's your responsibility now. And I would be sequestered to the care of that institution with very little regard for my rights. So these appeals are put in place to safeguard our patients' rights. So there is a review panel that looks at the criteria, and I apologize, I just realized there's a spelling error there. Criteria for involuntary admission or involuntary ECT or the CTO. Make sure that that criteria is being met. The patient and or representative, so the official representative or their own lawyer, if they so choose, can attend and present evidence and say their side of the case. The doctor then presents their side of the case, and the review panel will go and make a decision. If that decision is upheld, meaning the person stays involuntarily, the person receives ECT treatment, or the person is subject to the CTO, the patient is free to appeal that to the Court of King's Bench. And again, as I said, these appeals are put in place to safeguard individuals' rights that are subject to the Mental Health Act. So in summary, the Mental Health Act has been around for a very long time. In its current iteration, we've had it since 1986, and there were some amendments about in 2015. But we've had this type of legislation that determines who receives care and under what conditions for a very long time in Saskatchewan. It guides decision-making on the part of clinicians, so nurses and doctors and people involved with supplying that care, and it also safeguards patients' rights that are subject to the Mental Health Act. Again, this isn't an all-encompassing summary of the Act, but it can be a little bit intimidating for people that are new to it. So these are some of the highlights that you may see out there in your clinical practice. So I hope you've enjoyed this. I hope it's helped you with your studying. And yeah, I hope this has helped. So good luck with your clinicals and your classes, and I hope this helps you understand the Mental Health Act a little bit better.